Good evening, ladies and gentlemen. It's a pleasure to welcome you to this evening's federal bar program entitled Perspectives from the Bench and Bar about Multi-District Litigation. My name is Randy Sue Pollack, and I'm the president of the Northern District of California's chapter for the Federal Bar Association. Before we begin, I'd like to make a special welcome to those of you who are members of the Federal Bar Association, and to encourage those of you who are not yet members to please join. The Federal Bar was established in 1920 to serve the interests and needs of the federal practitioner, both public and private, the federal judiciary, and the public that we serve. Our chapter here in the Northern District is an active one, and we are connected to the national office, which has over 18,000 members and 2,200 judges. I'd like to point out to you the upcoming programs that our chapter is doing. On April 11th, we have a program entitled Navigating the Bureau of Prisons. We will have 4 former Bureau of Prisons employees, a former warden, head of medical director, and 2 treatment specialists who will tell you the ins and outs of understanding the Bureau of Prisons. Then on May 1st, we have a program here entitled, which will be a recreation and a reenactment of the trial of Vincent Chin. Judges Lynn and Thompson will be a part of that program, as will practitioners from our bench, our bar rather. Then on May 21st, we will be holding our annual Views from the Top program with our United States Attorney, Izzy Ramsey, as well as the head of the SEC and the Antitrust Unit. Then on May 22nd, we will have our special high school civics program, which Judge Gilliam is heading. That's a special program that I encourage many of you to come to. It's fun to see the high schoolers as they give us their program. And then on June 11th, we have a program in San Jose entitled Storytelling in IP Litigation, presenting complex technical concepts in jury and court trials. That panel will consist of Judges Van Heulen, Kong, Judge Freeman, and Paul Graywall from Coinbase. I encourage those of you who are law students or law clerks to please join. Membership is free. And those of you who are on Zoom, please post your questions in the Q&A. Thank you, and I'll now turn the program over to Judge Tiger.
Thank you, Randy Sue. Everybody hear me okay? Welcome to this evening's program. As Randy Sue said, I'm John Tiger. I'm one of the judges here on our court. I don't really know anything about MDLs, but that's why I'm the moderator. Fortunately, however, I'm joined by a really extraordinary panel, and I'll introduce them in just a second. Let me just ask for a show of hands. Who has not ever appeared as counsel of record in an MDL? You've never done that, raise your hand. Okay, so that's a healthy number of folks. I'm going to give you one statistic. I think Judge Caldwell will give you more statistics in just a moment. As of December 31, 2023, there were 167 multi-district litigation dockets pending in 46 federal districts before 142 transferee judges and comprising 456,669 cases. So multi-district litigation is an incredibly important part of the federal civil judicial landscape. And we have an absolutely terrific panel to help discuss the current issues in MDL practice. To my right is Judge Karen Caldwell. She's a United States District Court judge for the Eastern District of Kentucky, to which she was appointed in 2001 by President George Bush. Since 2019, she has been the chair of the judicial panel on multi-district litigation. She'll, I think, tell you a little more about what that panel does. Before taking the bench, she had a record of both significant achievement as a lawyer and outstanding service to the community. She has been at various times the chair of the Kentucky Bar Association's Publication Committee, the editor of Bench and Bar Magazine, a member of the Character and Fitness Committee of the Kentucky Board of Bar Examiners, and she serves as a trustee of her undergraduate alma mater, Transylvania University. It's a little in the weeds, I admit. I have to say a word about Transylvania University because it's got a very cool name, so I looked it up. It was founded in 1780 in Kentucky and is the alma mater of 2 United States vice presidents, 2 U.S. Supreme Court justices, 50 U.S. senators, 50, 101 U.S. representatives, 36 U.S. governors, 34 U.S. ambassadors, and Judge Karen Caldwell. My next panelist is already very well known to you. That's our own Yvonne Gonzalez Rogers, who's sitting to Judge Caldwell's right. She was appointed as a district judge by President Barack Obama in 2011. She has distinguished herself as a very strong member of our bench and the author of noteworthy decisions in the areas of patent law, privacy, and antitrust, just to name a few. In the area of MDLs, she has presided over the lithium-ion battery antitrust MDL, the Oceana air crash at SFO MDL, the In-Ray United Specialty Insurance Company Ski Pass insurance litigation, and the In-Ray social media adolescent addiction personal injury products liability litigation, which I think has the longest name of any MDL. Before she was a judge on our bench, she served as a judge on the Alameda County Superior Court, and before that was a partner at the Cooley firm. She too has a long list of public service achievements, including having served on the Princeton Board of Trustees from 2014 to 2018. To my left is Sarah London. Sarah is a partner in the San Francisco office of Leaf, Cabraser, Hyman, and Bernstein, where she specializes in class action and mass tort litigation. She has been named a Super Lawyers Rising Star for 8 consecutive years and was a 2015 finalist for the Consumer Attorneys of California Street Fighter of the Year Award. That's a great award name, honestly. In 2019, she was appointed chair of the Resource Board of the National Association of Women Judges, and she is counsel of record in both the Juul, that's J-U-U-L, MDL here in this district, as well as the Uber MDL. To her left is Neil Pottishman. Neil is a partner at Davis Polk, where he leads the firm's West Coast commercial litigation practice and is co-head of their Northern California office. His practice focuses on class actions, including securities, antitrust, RICO, and consumer protection, as well as other complex commercial disputes, and he also handles internal investigations and regulatory matters. He led Davis Polk's team in a court victory named to the Daily Journal's top verdicts list for 2020. Benchmark Litigation and Chambers USA recognized Neil as a leading litigator, and Law 360 has named him a class action MVP. Neil has been counsel of record in the LCD MDL, the optical disc drives MDL, the insulin pricing MDL, and the Neurontin MDL. So, an incredibly well-qualified panel on both sides of your moderator. I'd love to start with Judge Caldwell, and just let me ask you, Judge, can you give the audience a little bit of an overview of the JPML process, things like how the panel is composed, what kind of cases come before the panel, what's the mission of the panel, and some relevant statistics, that sort of thing?
Thank you very much. It's such a pleasure to be here and here on this panel with such good friends and colleagues and capable counsel. I'd also like to take just a minute to thank Randy Sue Pollock, who invited me to come here. She was held captive in Kentucky for 6 weeks for a criminal trial during COVID. We were the only trial, the only federal trial going on in the United States during COVID. We had started the case in late February before the world shut down in March. The jurors wanted to go on. There were 5 defendants. I think 4 of them were from California, and their lawyers and their paralegals. And so we developed a scheme by which we thought we could safely proceed. And with a lot of hard work and a lot of very good luck, we were able to complete the trial. And I think Ms. Pollock's client was acquitted, so she had a very good experience in Kentucky. And I hope she'll come back and practice there again. But let me first tell you just a little bit about the JPML, the Judicial Panel on Multidistrict Litigation, what its mission is, how we're organized, and what we do. The mission of the panel is set forth in 28 United States Code Section 1407, and that is to determine whether federal civil cases pending in different districts should be transferred to a single federal judge for pretrial management. That basically consists of discovery and motion practice. The centralization process is designed to create efficient efficiencies and to provide greater convenience for the parties and to improve and promote the litigation in fairness and efficiency. The panel itself consists of 7 judges from 7 different federal judicial circuits. All of us are appointed by the Chief Justice of the United States, and although the statute doesn't provide for a term, traditionally we serve 7-year terms. The panel is open to both circuit and district judges. Right now we are all district judges, but typically there has been at least one circuit judge on the panel. And I don't really know, I haven't asked the Chief Justice why there is not currently a circuit judge on the panel, but we are all district judges at this time. Now, we represent the districts of Massachusetts, the Northern District of Illinois, the District of South Carolina, the District of Utah, the Southern District of California, and the District of New Jersey. And of course, one of our panel members, our former panel members, is Judge Charles Breyer, who sits here in the Northern District of California. Actually, the panel operates like a small court. We have our own procedural rules, we have a clerk's office, we have staff attorneys, we have electorate case filing. You can learn more about the panel and its work at jpml.uscourts.gov. You can find out a lot of information there about the panel members, how we operate, how to file a case, what the procedures for filing motions are, and how the panel remands cases back to the transfer courts. Now, our duties in determining whether cases should be centralized also includes evaluating and assessing the impact of the decisions that we make on the federal civil docket. We inform and educate judges about practices and procedures that we believe will add to the efficiencies in their cases, help them avoid problems in their cases. We collect information regarding the progress of the MDLs. We like to, since we appoint judges who oversee these things, we like to know that those judges are paying adequate attention to their cases, so we do follow their progress. We consider motions for remand back to the original courts and of those matters that are pending within MDLs, and of course, once those cases are concluded in MDLs. We also survey judges about important issues arising in MDLs. Now, you might ask, how does something become an MDL? How does it come before the panel? Well, again, the rules provide the mechanism, but essentially, a party or parties file a motion for centralization before the panel. Opposing parties can respond. There can be an opportunity for a reply by the moving parties. Then there is almost always a hearing on those petitions to centralize. Sometimes the parties will waive. Nobody wants a hearing and they're happy to have us consider it on the papers just like you would in any other federal court proceeding. But the vast majority of the cases, a hearing is requested and parties appear in support of or in opposition to the motion to transfer. After the hearing, we retire. We sit in bunk every other month in places all around the United States, because this is truly a national practice and people come from the East Coast, the West Coast, the South, the North, and the center of the country. We try to move around to those particular venues. I guess my theory is we want to inconvenience everyone equally, so we do move around across and around the United States. We hear arguments in support of or in opposition to centralization. People say the arguments are really, really short because we don't allow people to argue for more than a minute or two. Well, in truth, the arguments are much more like an appellate argument where we allow each side about 20 or 25 minutes. Sometimes we allow more time if the case warrants more time, but that time is often divided among members of the supporting or opposing parties so that they can each address a point of interest with respect to the reasons for centralization. So when you hear people say, well, you've only got 2 minutes to argue in front of the panel, well, that's because there are 10 people arguing for 2 minutes. Sometimes there are people who argue for 3. Sometimes there are people who argue for 1 minute, but that's largely because the point that they have to make may not take as much time. And I'll tell you one little side story that's very interesting. Before COVID, when we were in hearings, when someone came up to argue, the judges just jumped in on them, to asking questions, just peppering them with questions. And before the poor attorney could even answer the questions, their time was up. Well, I'm happy to say that during COVID, we did not miss a single hearing. We were able to maintain our docket. We were able to maintain our hearings, but they were all on Zoom. And I quickly realized that there was no way Zoom or I or the lawyers could manage all 7 judges shooting questions at lawyers on Zoom. There was no way a court reporter could handle it because he or she was not in the room with us. So we adopted the practice that the Supreme Court has adopted, and that is we allow each counsel to make his or her appearance, make their argument before we begin to ask questions, and we ask questions only after the argument has been completed. What I have found, by the way, is that all the lawyers who used to complain about not having enough time will very often yield the balance of their time if the panel has any questions. So it gives me a little more confidence in the time that we're allocating to our arguments. More importantly, I thought that after COVID, lawyers would want to continue appearing online because it's obviously less expensive and you don't have to travel all over the country. I have yet to hear any lawyer who practices before the panel suggest that we discontinue personal appearances. Not only do they feel that it's important to come and appear in person, but I think a lot of work gets done outside the courtroom among the parties who agree and along with the parties who disagree. And I used to have an old motion practice when I was in private practice. We had to go out and have our motions had to be heard by the state judges. And what I always found is the judge was late on purpose because he figured we would work it out before he came in and took the bench. So I sort of liken this to old-fashioned country motion practice, in that the lawyers actually have a lot of time to hone their motions, work on what they can agree on, and more clearly identify the places in which they disagree. What does the panel, and I don't want to take too much time here, but let me just point out what the panel considers when it receives a motion for centralization. The first thing that we look at is there a fact in common? And that is to determine whether or not a fact is in common. And I have my notes out of order here, so you're going to have to excuse me for a minute. We do not consider jurisdictional issues. Jurisdiction is not an impediment to centralizing the case. The case can be centralized before a judge who has no jurisdiction over the matter. Again, the transfer is for the purpose of pretrial discovery and pretrial case management, so the judge doesn't have to have jurisdiction over the case. And we look to the case as to whether or not there is a central issue of fact, a common issue of fact. It does not matter about the strength or the merits of the position of the parties. We look at, are these a group of cases that have facts in common? And whether federal actions share common issues of fact, then we look at whether or not centralization will enhance the convenience of the parties and promote the just and efficient proceedings. There are a bunch of non-exclusive factors that we consider, such as the number of pending cases. Are there more to come? Sometimes the numbers matter, sometimes they don't. We centralize cases very often that have a handful of cases. And in some cases, we centralize cases that have 250,000. So the numbers can be important, but not always. We look at the number and complexity of common issues, but again, we only need one. We look at the likelihood of duplicative motion practice. duplicative discovery, the potential for early dismissals. Will the characteristic of multi-district be lost? We consider the procedural postures of the action and whether or not there are alternatives to centralization, such as 1404 transfers. Since its inception in 1968, the panel has created more than 1,800 centralized matters. Now, once we look at whether a matter is to be centralized, we consider the questions of where and before whom. Once again, there is a list of non-exclusive factors that we consider, and this is where we think it's important for the parties to bring other matters to our attention that are relevant to where and to whom. But we look at where are the parties. We look at where will the discovery take place. Where are the records? Where are the most cases filed? Where are the most advanced cases? Where was the first action filed? Where are the related state court cases pending? Where are related bankruptcy cases pending? And last but not least, where do the parties want to go? Very often they want to go there because, like all good lawyers, they think that their client might have an advantage in that forum. Some people call it forum shopping. I call it smart lawyering. But I do think that we look at where the lawyers want to go because sometimes they have a very good reason for that request. Very often, the question is not whether a case should be centralized, but where it should be centralized and before whom. And the before whom question is also a large question. Every year, we survey every single federal district judge. We want to know about their interest in presiding over an MDL, their capacity, and their experience. So we look to that survey when we get recommendations. We want to be sure that the judge has the time and availability to take on this case. What you need to understand about MDL judges is they don't quit their day job. They still have a full criminal and civil docket. These cases are assigned to them in addition to their regular docket. We don't get extra law clerks. We don't get a reduction in our dockets. Judges do this, and Judge Breyer and I were just talking about this, because district judges by nature, we're problem solvers. We love organizing. We love trying to get to the end of what seems like an intractable problem. And the MDL is the perfect mechanism for that problem-solving talent to come out in members of the federal bench. We also look at the judge's docket conditions and what kind of shape their motions report is in. If somebody has 150 pending motions that are more than 6 months old, they're probably not going to be assigned an MDL. Also, we look at the docket conditions of the circuit. If there's been a major disaster, let's think about Hurricane Katrina back 20 years ago in New Orleans. I don't think that you're going to see any MDLs going to New Orleans after an event like that when a docket is literally drowning in local matters. We also look at the experience of the judge. Not necessarily specific experience in MDLs, but for example, if a brand new judge was a patent attorney, I think they would be a viable candidate to take on a patent case. Remember, every single kind of case is subject to being centralized in an MDL. So we had a case where we gave a brand new judge an MDL because she had the particular experience to address that case, and the parties also recognized that. We also try to make sure that we're building a deep bench of experience on the bench. And so we consider the gender, race, geography, and experience of the judge. Likewise, those judges consider the gender, race, geography, and diversity of experience when appointing lead counsel. And so those are the factors that we look at as we consider whether, where, and to whom we assign centralized cases. Currently, roughly, and these are very rough numbers, 455,000 of the 655,000 pending civil cases in federal courts are in MDLs. That's roughly 2/3, 65 to 70%. And I know every time I give one of these speeches, I have to qualify with it. That number fluctuates a lot from week to week, from month to month, but that's about where it is. Now, that percentage seems pretty high, but that's in large part attributable to one MDL. The 3M earplugs, combat arms earplugs case. Right now, there are 275,000 cases pending in that MDL. It's the largest in history. If you take 3M out of the federal docket and out of MDLs, what you find is that about 48% of the civil docket is an MDL. So really, the 3M MDL distorts all of our statistics. And at about 40 to 50% is where MDLs have been pending in this federal civil docket for a very long time. It fluctuates up and down, but not dramatically. Right now, of all the pending MDLs, there are 20 MDLs that have more than 1,000 cases. There are 28 that have 100 to 999 cases, 73 that have 11 to 100. So you can see that most MDLs are right in that sweet spot at about 100 to 999 cases. Now, what we also have noticed since 2014, the number of motions for centralization has trended downward. There were a lot more motions filed back 10 years ago than are being filed today, but they denied they denied more motions. And what I think is that as that trend has come downward, what we're seeing is better targeted motions, better motions being filed. And this year we only had 29 motions, but we granted 19 of them. So you can see the grant rate's gone high, but I think that the quality of the motions is better than it was when the statute was newer and people were trying to figure out what was going on. And before I close, I really have to recognize the judges of the Northern District, California, for their work in assisting the federal judicial system in handling MDLs. Currently, 11 judges here in the Northern District have 15 MDLs assigned to them. 2 are among the very largest MDLs with more than 1,000 cases. Judge Orrick has the Jewel case, and Judge Chabria has the Roundup cases. Those are 2 of the largest MDLs. We also have Judge Chesney, Judge Gonzalez-Rogers, Judge Tiger, Judge Seaborg, Judge White, Judge Gilliam, Judge Davila, Judge Breyer, and Judge Chin. Some have more than one. All of them have had, over the course of the years, more than one MDL. But right now, I think Judge Breyer has 3, and Judge Orrick has 2, and Judge Chabria has 2. So some of these people are doing double duty and managing their local dockets. So I have to give a special shout out to all my colleagues here in the Northern District of California for their work they're doing. I'm sorry I didn't mean to take so much time, but I hope I've set it up for everybody to talk on their subjects.
I think this is exactly the information that our audience came to hear, so that's a great way of starting off our program. I'll just add a little bit to one of the statistics that Judge Caldwell gave you. As she told you, it's about 2/3 right now of the federal docket is comprised of MDL cases, which is a huge number, and that is in large part because of the distorting effect of the 3M combat arms earplug case, which, as she said, has 275,000 cases. It's pending in the Northern District of Florida. But even in 2019, which was a year in which there's a relatively low percentage, it was 38% of the federal docket was MDL. So it's always been, I mean, the statute's been around since 1968, but within recent legal history, MDLs have always been a giant proportion of the work of the federal courts, and they're going to continue to be for some time. So let's talk about kind of practical implementation on the ground. Judge Gonzalez-Rogers, maybe I could start with you. What are some do's and don'ts for lawyers who are litigating an MDL? You've done 4 of them. You probably have some views on that question.
Well, good evening, everyone. Welcome to the Northern District of California. We're glad to see everyone and welcome everyone online. So just so that we can get the conversation going among all of us, what I would say my biggest do is, I'll take a modified quote from Jerry Maguire. Help us help you. Help us help you. That's what we're here for. As Judge Caldwell said, look, we've been given this problem. And our job is to fix it, to solve it, to get to the end. You obviously are going to know much more about all of this than we do. So when you come into the courtroom, we need to understand from you what you think is the most efficient way to get to the finish line. So that's what I'm always looking for. After we get through the preliminaries of appointing counsel and that kind of thing, is the ability to figure out the most efficient path forward. And that means meeting and conferring in advance. That means focusing on the big issues. Don't sweat the little stuff, and don't talk to me about the little stuff. You all figure out the little stuff, because that's really not my best use of time, right? So we want you to figure things out as much as you can, and then come to us. Reasonable people can disagree. We understand that. Come up, make your arguments. We'll make a decision. We'll move on. I mean, a lot of this is gray. We don't have a precise way. I've done 4 MDLs. We've done them, and I've done them all differently, because they're different MDLs and they require different things. So that would be my big do. Sean, thank you. Or Judge Tiger.
I bet everyone's wondering what the don'ts are, but maybe we'll come back. Sarah, let me ask you, from your perspective, what has worked best and worst for you and your colleagues in litigating in an MDL?
Sure. Well, I'll start with what's worked, and that's working with creative, hardworking, diverse, collaborative leadership, counsel. This is a team, and having a strong team is 98%, I think, of what leads to success in managing an MDL. Initial orders that keep things simple, streamlined, and strategic, focusing on the big picture issues, what is common, what is urgent, and what is important. That sort of Venn diagram. I try to keep focused on those issues and not get distracted by shiny objects, as some of us have put it each time we get together, is what is really important, what do we have to do now, and what's common to get the job done. We also think that frequent status conferences really help because it brings us to focus and rises up those important issues, and it gives us that kick we need in the pants to decide those smaller issues and move on. And what's really important? What do we all want to bring to the judge's attention and get decisions on now? But also aggressive deadlines. It's really important that we have, I think, something to focus all of our attention toward and keep us moving, because there's a million reasons to slow down and delay. But keeping our eye on the prize, keeping aggressive deadlines is really important, and having trial dates is really important to that effort. And I think we're going to talk probably a little bit later, Judge, about what those trials might look like and how we can be most efficient with our time and effective at choosing what to try and when. But regardless of that, having an early trial date and a clear effort towards that trial really helps. And the last thing I'll say that's really important, that I don't know that I would have said this before I did an MDL, but having really effective, thoughtful, and smart counsel on the other side of the V is so important. And finding that counterpart, finding that person that you can sit in the hallway with, that you get on a side text chain with, to work things out, to be reasonable. Because when you find who that person is, or those people, there's so much that can get done because we are professionals and we are all really in it for the same goal, which is to get the problem solved, get resolution, and do best by our clients. And when we find those folks we can work with on the other side, it really is so significantly important to me in how well an MDL is going to go.
So there's a rule, proposed rule floating around right now, an amendment to the Federal Rules of Civil Procedure that would is supposed to prompt more early case management in MDLs. You said a minute ago that one of the things that works is early orders that focus on things that are important. Can you give people some examples of the kinds of subjects that should be covered in those orders?
Sure, and actually the proposed Rule 16.1 lays a lot of this out in the advisory comments and talks about some of this as well. But direct filing orders, so making it easy and streamlined and organized for cases to get filed directly into the MDL, it just reduces the headaches and administration.
And for folks that don't know what you mean instead of having to, let's say the case has been centralized in the Northern District of California, instead of having to file in the Northern District of Ohio and then wait for someone to do all the transfer stuff, just being able to file it right here in this district.
That's right. So you can file, and then everybody reserves their rights, and you can create a form that says where you would have filed if your client doesn't want to file in Northern District of California, for example. But it just makes it easier and makes it easier to administer and keep organized, and I think for the court as well, to keep that administration. Other types of orders that are really helpful at the beginning, electronic service orders, making it easy to serve, figuring out what the defendant's needs are with that. In some cases, they want to have a notice on the docket. Okay, we can be creative and think through that, but ways that we can easily make it easier to get cases on file so that sooner rather than later, we can get our arms around what's the scope of this MDL, how big will it be, what kinds of cases will be filed. Other types of early orders that can help, privilege log orders, discovery procedure orders, obviously ESI protocols are something that are very important to get done early. We also, scheduling orders, having an early scheduling order that, for example, in the Uber MDL, Judge Breyer entered a pretty early scheduling order that included certain types of off-the-shelf discovery, just to get things going, the kinds of obvious and clear types of discovery that we all know is going to be part of the case. Let's get that exchanged. Things like with Judge Gonzalez-Rogers, documents that have been produced to regulators or in state proceedings. Let's just get that turned over. Let's get the parties moving. Those are the kinds of early effective orders that get the parties started. Judge Cisneros, I know, and I think some of the other magistrate judges, just like Judge Corley did when she was a magistrate, set up more expedited procedures for discovery. So here's how the parties are, when they're going to meet and confer, when you're going to decide that there's a dispute that's ripe, how you're going to present that to the court. These kinds of MDLs are so complex, or they can be, and our goal is to make them simple and to break them down into parts and get the issues decided and work really hard to try to do them on our own. But when we can't, let's get them resolved and get them moving forward. And having those types of orders help us stay organized, not fight about the fights.
Let me just add a couple of things. The first is, there's mention of Judge Cisneros, and we're lucky enough to have her here in the audience. I can see her there. And, civil discovery is the backbone of civil cases, in all almost all civil cases, including MDLs. It's not different. And we are lucky to have such an incredibly strong magistrate judge bench here who are doing most of the discovery, not for all judges and not in all cases, but doing most of the discovery for most of the judges in most cases, including MDL cases. And that's a big part of the reason why I think we continue to be a favored forum for the JPML. And we like our status as a favored forum, by the way. We want them to keep sending us MDLs. We like working on them. And then I forget the other thing I was going to say, so that's good for you. Let me ask Neil, same question for you, sort of what works and what doesn't work in litigating MDLs?
Sure, and I'll just give a somewhat standard disclaimer at the outset that the views here are mine, and they're not my firm's, and they're certainly not my clients necessarily. For what it's worth, I agree with a lot of what Sarah had to say. The challenge for us, I think, a significant challenge for us is every time you have a case management conference on an MDL in a faraway jurisdiction, you get a lot of lawyers in the room, you get a huge amount of expense, you've got clients asking the question sort of, is this necessary and how do we do this efficiently? So it's an expense and it's an inconvenience and it drags everybody away from their offices. The flip side is I think it's the primary way things get done, and I do think that it's the best way to make progress with case management because the judges, I don't know if they would believe how much goes on behind the scenes, let's say just within the defense group, trying to figure out what positions to take. And then you get on a meet and confer and you say one thing, and maybe on the plaintiff side, they want to process that before they respond to it. And so it can be a sort of glacial process of working through issues. Sometimes it's literally also, right, if somebody, probably it's true on the plaintiff side too, but on the defense side, if one defendant's lawyer says, my client has this concern, you don't typically want to say, well, we don't have that concern. You got to think about it, and then you got to flag it for your client. Do you have that concern too? And so it becomes the slowest part of litigation and thinking things through, multiplied by as many parties as you have. And I think there's no substitute just for getting into the room with the judge, having a judge who sets expectations for how fast they want to move things along, saying, look, let's get this ESI protocol in by this date. Let's get the discovery confidentiality order in by this date. I will say that I disagree in part in terms of what works. I do think in some MDLs, it feels sometimes on the defense side like it's a push to see when we can get to the point where we're finally talking about settlement. And a lot of times I think for our clients, they think they may have important dispositive motions and they really believe firmly in them. And part of what may convince your client to think seriously about settlement is being convinced that you in fact got a fair hearing on that motion, that is part of the process. And so, defendants typically want to see equal discovery obligations, meaning if they're going to provide a lot of discovery in the early stages, we're not just going to pick 3 plaintiffs and do discovery of them, we're going to do discovery of everybody, and we're going to have a real chat about when we're going to do expert discovery and summary judgment. And I think at least in my experience, when my clients get the sense that the judges are taking those seriously, it's a real step in the process. It makes it more productive sort of throughout. I will say on the margins, direct filing orders, I think defendants, we've sort of lost the battle on this one. I think that's the way it's going to go. I think in general, we're not super enthusiastic about making it super streamlined to file a case because there's a lot of copycat cases that get filed. Some of them are good, some of them are garbage. And the more you streamline it, the more you potentially invite garbage in. But I'm now in MDLs where the judge says at the beginning, give me your direct filing order. And so you don't necessarily fight about whether you should have one. You provide the best direct filing order you can. And I otherwise largely agree with what Sarah said on that subject.
And I think if I can just jump in, some of that creativity and, again, the efficiencies in the work that we do on the front end, on the motions to dismiss, for instance, we understand that defendants want their shot, but we also don't want to do this more than once. And so having productions of discovery early so that you can have the best master complaint matters, because if, we certainly don't want to do it 2 times. So I do think, again, there are creative ways to do things, to structure discovery in such a way that plaintiffs are only getting the critical issues or the critical discovery they need to have a more fulsome complaint, so that then your motions to dismiss are based upon a more thorough record.
I'm going to toss in something about dispute resolution that I think is just as true in MDLs as it is in general if you're a judge. And that is, we're decision makers for a living. That's what we're like, decision machines. And, of course, I like it better when the lawyers focus on the things that I think are important, but I also understand that I might not know what's very important from their perspective. Neil touched on that a little bit. There's a great essay that Larry Fox wrote. Every time I think something is 10 years ago, it was 20 years ago. So it's probably 20 years ago. Larry Fox was one of the grand old poobahs of the ABA. I haven't seen Larry in a little bit. I don't know how he's doing. But the article was in Litigation magazine or one of the ABA publications, and it was said something like 15 things that you should do if you're a judge that we wish you would do. I loved the article because no one ever says that to us. People just sort of genuflect. And so he said, please do these things. And one of the things had to do with discovery. And he said, when we come to you and we're fighting over some discovery thing and it looks like a mouse meat issue to you, don't look down your nose at us and chide us, just roll up your sleeves and decide it. We don't want to be here either. It really stuck with me. And so I think, what I would say is, if you try to be gracious in your presentation and collegial and professional, hopefully we're treating all of the disputes that you bring to us with the right amount of dignity, right? Because that's the process. But it's also true that some things really are kind of mouse meat disputes. And here's the takeaway. Think about those disputes as baseball arbitration. Okay, I actually don't know that much about baseball, but someone explained baseball arbitration to me once, which is if the player and the owner get in a beef about the salary, they go to a professional arbitrator who has to pick one of the parties' positions. They have to. So let's say the player thinks, I'm worth $10 million. That's his position. And the owner says, well, the player's only worth $5 million. And the market would say the player's worth $8 million. The arbitrators have to pick $10 million. They can't pick 8. And they're going to pick 10 because they'd rather be wrong by 2 million than be wrong by 3 million. That's how we're deciding. That's how most of us are deciding your smallest disputes, okay? We're not going to say, oh, they want the discovery cutoff in 32 days and the other one wants it in 38 days. Let me consult the Rudder Group book for a while and see if I can figure that out. We're just going to pick one. So if you are, I know you're under a lot of pressure from your clients to take positions that make your clients feel good. But if the position makes you look unreasonable, and meanwhile the other side has come much closer to the center, they're going to beat you 9 times out of 10. And it's in all of these early proceedings that we're just talking about now, these very early conferences where schedules are being set and discovery obligations are being worked out, things that are going to haunt you for the rest of the pendency of the MDL, where hopefully that principle could be a little helpful to you.
Well, said a different way, right? Integrity matters. And you have a very few limited chances to make a first impression. We are trying to figure out who we can trust and whether we can trust what you say and whether you are focused on the right issues or whether you are just being obstructionist. And I think that matters. I don't know about how you feel, Judge Caldwell.
Well, it does. And I think particularly in the MDL context, I mean, you know, the practices and principles that apply in complex civil litigation really carry over into MDLs. They're not that different. There's just more of it. It's just bigger. And I think that, you know, getting enough information, trying to distill these issues down to make important decisions so that there is enough information for the parties to understand the strengths of their case, evaluate the risks in their case, and come to understand the real value, not just the value that the plaintiff spouts out or the value that the defense spouts out. We're really trying to make some order out of all this chaos. And so I think that I can't agree more with Judge Gonzalez-Rogers is that we need people of integrity who do the work, who meet the deadlines, and sometimes that's impossible. And if you come to us and tell us why that is impossible, not that you just didn't get around to it or that you refuse to do it because your client really didn't like it, we need solid reasons, and judges can be reasonable, and we feel more confident in that decision making when we have the information that we need to make a decision.
All true. Let's talk a little about practice. So if you have 600 cases or even 50 cases, you obviously can't try them all. You can't. I mean, people will come in your courtroom and tell you, we're going to try them all. Okay, that's fine. But you can't. So we try them as what's called bellwether trials. Bellwether is a word that just means an indicator of something that's going to happen in the future. So you pick a case and you try that case, and then hopefully it will convey case value information about the other cases to the lawyers. Then they can eventually settle your whole MDL. That's the idea. So, Sarah, tell me about how you would pick which case you would propose as an MDL. I bet your factors will be a little different from Neil's. We'll find out about that in a second. But let's start with you. What do you think about when you're selecting a bellwether and trying it?
Well, I want to start with the value of a MDL trial. I was really struck, Judge Caldwell, but when you emphasized several times that the MDL is for motion practice and pretrial. But of course, I'm coming in the first day of my MDL saying, I need a trial date. And, I happen to have the great fortune of being an MDL practitioner here in the Northern District, where in both of the MDLs that I've been involved with, the company is also based here. So we can try cases, and that may be another point just to talk about in a moment. But in terms of why do we want trial dates? Why is that important to aim towards? Well, in addition to an important factor of finding the value of the case, part of that is the exercise of trial helps the parties understand the strengths and weaknesses of their case. It's one thing to put it on through motion practice or to submit it in papers, but when you have to take that expert that you have won on the Daubert motion, to survive, they've survived, and they get on the stand and they're horrible, or, judge, might strike a lot of their testimony or whatnot, just hypothetically, not any of my experts, obviously. But, these are, these are really important functions for the parties to get real about the value of the case and the case that they've been putting together. So understanding the strength of your case, the witnesses that you have, the experts that you have, the evidence that you've been toiling behind the scenes to present, how does a jury really see that? And not just as the value of each individual case, right? That is an important piece of it. And I think I'll get to that in a second. But in terms of how will the jury evaluate the story that we're telling as plaintiffs, the liability story, how does that evidence come in? And I view my role as leadership as being my job at the end, if I'm doing my job, is we are creating a package that if we can't reach a global resolution, if people can't settle at the pretrial stage, that when they go and their cases are remanded back to a district of jurisdiction or where the case is going to be tried, that we've gotten pretty far down the field in terms of here's a package of testimony. We take hundreds of depositions sometimes in these MDLs. It's a ton of work. But the real effort that goes into, on both sides, the parties narrowing those depositions down from 5 zillion hours to whatever, 30 hours of trial testimony is a huge amount of work, but hopefully that will be very beneficial to the plaintiffs and the courts that get the cases at the end. But the exercise of preparing that case for trial, of rising those significant issues, motions in limine, so not every little one about every individual plaintiff, but the big important ones, to have the judge who's been overseeing that case for 5 years, who knows that case inside, outside, upside down, who's read all the transcripts, who's ruled on the Dauberts, who's ruled on the motions to dismiss, for them to sit in court and help create that package by ruling on those important issues and those important motions. It's just extremely important for the ultimate resolution of the case. If we can't do it, pre-trial, then that's going to help us at the end of the day. So trial itself is extremely important in the MDL context for creating that package. And so in thinking about what case to try and how do we get to that trial, to me, it's really about, we want to try cases that we'll try. And I know that sounds very silly, but a lot of exercise around what's the most representative case and slicing and dicing the data, I think that can be useful. It's a nice to have. It's nice to be able to categorize cases and recognize that some types of cases and some types of injuries, we could try some of those cases and get a sense for what the values would be. I think that's somewhat useful. But I also think it's most important that we're getting cases that are actually going to try. That means not really outliers on either way. A case we're not going to spend 3 months getting ready for trial on, that's going to be resolved on a statute of limitations issue, or some other outlier problem within the case that just doesn't help everybody. This is an enormous amount of work to prepare for an MDL bellwether. For the court, it's an extreme amount of work. I can't even imagine how much work it is for you. It's a lot of work for the parties, and if those very small case-specific issues are going to they'll make those cases go away, it's just a huge waste of time. So we try to look for cases that don't have those outlier or those very case-specific detailed issues or complexities that would derail the process and make it inefficient and ineffective. So you want things, I would say, more straight down the fairway. I also think it's important to let the plaintiffs, really pick who goes first, because they're going to put all this time.
This is called working the ref.
And effort. But it's also a reason, it's for part of the reason, is because we're going to put all this effort into it and to test that, how good is our evidence, how strong is our case coming in. And if the case that's being tried is not a good plaintiff case and the case gets decided on that fact, it just doesn't really help the overall resolution. It's easier to just dismiss that and it doesn't get the case resolved. So I'm a fan of that. But in any event, I don't think it's just, pick your best case. I think it's picking cases that go down the fairway, that will try, that don't have these unique, weird issues that make it unlikely to go. And then if you liked my proposal of plaintiff's pick, you're really going to like my proposal of multi-plaintiff trials, because I think that is really the way to go. Because when you don't have to worry about the idiosyncrasies of individual plaintiffs and what you're really focusing on are the common issues, and you're trying a number of plaintiffs together, it keeps the jury's attention on the, obviously each individual issue has to get decided at the end of the day, but you're really trying to understand what kind of case do we have here? What does that look like? And I think multiple plaintiffs allow for the fact that some may have idiosyncrasies you find out later, some will resolve, some will get picked off, but ultimately you have something to try. And I think that's important. And then finally, I've had a few thoughts on this. I've had the great fortune of being able to serve as leadership in the Jewel MDL that had 4 different types of cases. We had a class action, we had personal injury cases, school district cases, and tribal cases, not too far unlike what Judge Gonzalez-Rogers is overseeing right now. And in that case, we were doing, the bellwether selection in all these different types of case groups at the same time. And I think the overriding strategic choice that we made there that I think ultimately was effective was we need to work up all these different types of cases really on a parallel track so that if one type of case, for whatever reason, isn't going to get tried, there's an appellate issue. Or we're waiting on class certification appeal issues, or there's a dispositive summary judgment, or there's a key Daubert in one of these different types of cases, that we don't give up our trial date, that we're able to keep focusing and moving those cases toward trial. And what happened in the Jewel case that was really interesting is we were just on the eve of trial of one type of case. We resolved that section of the cases, and then we were able to pivot and use that good work product and have just a few short months later, like 2 months later, not years, another opportunity to try and get to trial. And that just allowed us to really get that case resolved in a very short, relatively short amount of time.
So I think Judge Caldwell wants to jump in.
Yes, I just wanted to clarify something, and I understand what Sarah was saying in that, like all civil litigation, virtually all MDLs settle. But that is not the mandate that the panel imposes on the transferee court. I think in academic circles in particular, there was criticism of the panel in that it said, you send these cases out to judges and pressure them to settle. We simply do not. There is no shame in a judge and the parties working through a case to a point at which they realize these cases need to go back to the original districts for trial. And they'll go back with depositions taken, with motions decided, with things that will make it easier for the original counsel to represent the plaintiffs. There is no shame in that. The fact that it doesn't happen very often is the same as it is in every other federal civil case. The parties get through discovery, they have enough information to properly evaluate their cases, and they resolve them. Expense is an issue. Trials are expensive beasts, and they come with unpredictable risks. So I just wanted to emphasize that the panel does not send these cases and say, Judge Rogers, if you don't settle that case, I'm never sending you another MDL. That's just not true. And there was some misconception about that, I think, in years past.
Well, Neil, I think you'd be happy to know that I think defendants should also have a view on picking bellwether cases.
I'm going to turn to Neil now on this bellwether question. Neil, I think Sarah's given you lots to work with. For example, I'm curious to know, as someone who generally represents defendants on a scale of 1 to 10, how awesome is it to have multiple plaintiffs at the same time in the same trial? I'm curious to know about that. Seriously, though, how do you feel about her comment? We're not looking for outliers. I think in my experience as a judge in bellwethers, people are looking for outliers. They're looking for the most awesome plaintiff on one side, the most awesome defendant on the other. They don't want any surprises. They don't want someone going out on a last-minute Daubert or, some other weird thing. But they're picking, they're picking their friends out of a crowd, basically. Alexandra Lahav, who's a professor, one of our great proceduralists, who just moved from Connecticut to Cornell Law School, wrote an article a few years ago saying, hey, in bellwethers, let's choose randomly, because that will give people better information than these outliers. I've probably mentioned that idea to 40 lawyers. All 40 of them hated it. So what do you think of that idea? Maybe you're the 41st, I don't know. And then whatever other thoughts you have about bellwether trials and plaintiff selection.
Sure. There was a lot there. Hopefully I made a deposit in the bank earlier when I agreed with Sarah so that now I can make my withdrawal, because there's a lot to disagree with. But I'm going to start with what may be the most interesting thing I'll say the whole night, which is the root of bellwether, because I didn't know, so I looked it up as I was getting ready. I don't know how many people know, but in the old days, goes back to 15th century, the shepherd would put a bell on the neck of the lead sheep, the sheep that everybody followed around. And that was the way the shepherd could keep track of where the flock was. If you could hear the bell, you knew where the whole flock was, because it was following that lead sheep, which happened to be called a wether. I have no connection between that and what I'm about to say, but I still thought it was very interesting. Look, there's a difference between, I think, a fork in the road between some of the MDLs, which I think, frankly, we've worked on more commonly, which maybe is antitrust cases, maybe some marketing cases, and some of the true mass tort cases where you end up with 275,000 or 100,000 kind of cases. And I think bellwethers may be truly inevitable in the latter context because you've got so many. I think they're maybe a little bit less inevitable in the former context. I think there's pretty clear tension between saying we want to get the middle of the fairway, but just let us choose. I think consistent with what Judge Tiger said, there's a tendency for the defendants to want to pick cases that they think they can win, and there's a potential for plaintiffs to pick cases that they want to win. I've never been in an MDL where anybody agreed to random selection, but I think, since I've already said it's not my client's view and not my firm's view, I think it makes sense. And it's true that if you pick 10 of those and teed them up, some of them are going to go away. Some of the reasons they go away may be useful. The fact that a certain plaintiff falls away because her case falls away or his case has a statute of limitations problem, there's value in that. One of the things, and I've read this in the academic literature, and I think it's true, the adverse selection problem, if you have plaintiffs who generally have control and pick very strong cases, it leads to a number of things. First of all, if they win, defendants say that's not representative, so this is not helping me to figure out what the cases are worth. You have more plaintiffs starting to come out of the woodwork to file their suits because now they think there's money there. And a significant problem, which I thought was pretty interesting, is the plaintiffs who don't realize that their case is not as strong as the plaintiff that just won. So they begin to have unrealistic expectations. So there is a problem on the defense side too, which is you may want to pick the weakest cases. But I think the reality of it is something that's approaching random would clearly help you find the center of the fairway. I certainly don't think it really ought to be, plaintiffs ought to be allowed to drive the bus too much. And I'll just make one other point. I think from a defense perspective, we see the pressure to choose bellwethers earlier and earlier. You get to, sometimes there's motions to dismiss. Let's pick one motion to dismiss in one of these cases. Let's move that forward. Let's move that case into discovery. Let's get that case ready for trial. And I think that makes everybody on the defense side super nervous because we don't know what we don't know. We don't know what's going on in the other cases that the plaintiff's bar has not pushed forward. We're not sure whether it is in the fairway or not. And we hate the asymmetric discovery that we're being sued by 500 people. We're going to have to provide a lot of discovery. You're just going to do discovery for 1 or 2 or 3.
Neil, I just want to ask a clarifying question. So is some of that kind of an N=1 problem that gets solved if you say, let's push forward a group of cases separate and apart from the selection of them?
Yeah, I think in the kinds of cases, the pricing cases, the sort of LCD kind of case that Judge Ilston had that Leif Cabraser was heavily involved in, I think there was a pretty good job to move, frankly, end forward. I mean, to move most of the cases forward. It was staged, right? There were tracks, and the tracks, I think, were incredibly well managed by Judge Ilston, and I think there were 3 trials in that MDL, but they happened a couple of years apart. But I think when we're talking about the cases where it's, it's fen-phen or it's earplugs, I think, yes, you could move a group forward, but I think in general, whether it's fact sheets or other things, the plaintiff should be having to participate in discovery. It's, from the get-go, generally, I think.
Can I just make one comment to clarify my comment earlier?
Sure.
So I just want to clarify, my position is not plaintiffs should pick and that's the end. I think like everything else with MDLs, we need to be working collaboratively and creatively. How do we solve this problem in this MDL? And what cases should be tried to get to drive resolution or to drive resolution of the common issues? And, I think that's a collaborative effort between the parties and the court. And I think randomness really deprives us of the strategic thinking and the creativity that we have in this bar and that everyone's coming to the table with, and hopefully with the goodwill of really trying to solve the problem. Of course, everybody's, that's the adversarial system. Everyone's going to, push for this or that or the other thing. But I think working collaboratively, and it's another one of these good early orders in an MDL, is a bellwether trial selection order, right? Where the parties confer about how are we going to do this? How are we going to get to deciding what we're going to try?
Well, in the social media MDL, I can say if we do this again in a couple of years, we'll have a bit more information for you, because my view is there's kind of an organic, kind of closer to random way to pick bellwethers, and what I would call a mathematical way. And Judge Kuhl, who's managing this for the California collective proceedings, she and I regularly talk about our 2 groups of cases, and she has decided she's going to be very mathematical about this. I think she has a grid that is about 16 by 16 different factors. They're filling it out. It's going to take them months to fill this grid, and that's how she's going to pick her bellwethers. After talking to a number of MDL judges, I've decided I'm going to take the more organic approach. And I've given them less time. They can choose based upon the information they have. And we're going to pick and we're going to go. And we're going to pick enough so that, by the end of the process, we can have things to try. So you're going to have same set of kind of cases, 2 different approaches. We'll see what happens.
And I should also make clear, I mentioned Professor Lahav's article because I think she's a wonderful writer. She's written a book called In Defense of Litigation that I also really like. It's a little plaintiff-y, so if that bothers you, just to tell you that. But it's a great book, and she's a great writer. I've not been persuaded yet to do random selection. And people get very concerned. They say, oh, well, the defendants are going to be so strategic. The plaintiffs are going to be so strategic. It's sort of like Judge Caldwell's comment about forum shopping. It's like, of course they are. That's their job. Can you imagine when they're saying, you know what, I don't care that much. I'll just take whatever plaintiff, So I think it's just another incident of the litigation adversarial system actually working appropriately. And these lawyers want settlement just as much as you do. They're not going to pick cases that are not going to ultimately help them in settlement. They're going to pick them in cases that they think are going to help the most by driving value in a certain direction. And it's not perfect. But I think I'm not aware of a better system. Let me ask a pop quiz question and see if I have any takers. I did a planning session before, and I pushed out an outline, and everyone's got the outline. So let me ask a question that's not on the outline, because it came up in the panel, I think, in something that Neil said, and that is, what do we think about cases that are in large pools of MDLs where some of the cases just are not very good? I don't like to use words like, garbage cases and stuff like that, but these are really not very meritorious cases. That topic bubbles up occasionally, and I just wonder, do any of you have a view? Do you think is it a problem? Is it not a problem? What do you think?
We had, with the MDL judges meet once a year, and we had a panel on this topic. And so when I came back, having just gotten the social media MDL, I said to the lawyers, we're going to address this by an order that requires someone in leadership with whom I have a relationship, and I can assert Rule 11, has to have contact with these plaintiffs, because otherwise you just get, hordes of kind of plaintiff machine or plaintiff law firms who are just, churning out plaintiffs with no real investigation and no real skin in the game. And that's how I'm going to try to deal with it, because I think it's an issue.
Anybody else?
Well, I have a friend who writes me fairly regularly, never heard of this guy, but says, I can get you 50 roundup cases for $250 a piece. I can get you so many jewel cases for, and I never heard of this guy. I think I must have attended some conference at which I was interacting with these, and I don't even really know what you call them, but client development consultants, which is what I would call them. But I think that lawyer advertising has contributed to it. I mean, how many of you have been driving in your car, you've heard, if you have ever seen Camp Lejeune, if you've ever heard the word Camp Lejeune, you may have a claim. And I'm not being critical of the plaintiff's bar here. I am being critical of people who would take advantage of lawyers, people who would take advantage of people who may have legitimate claims. Good plaintiff's lawyers have no incentive to accept cases that have no value, but they do have a responsibility to vet those claims to be sure they do have value, because that kind of claim can dilute a pool. And so I think it is a problem that really has been the creation of forces kind of outside the actual practice of law. And I've actually been to groups where I've heard plaintiffs' lawyers complaining about the people who participate in that kind of activity, because they feel that it is diluting the quality of their practice, it is diluting their reputations. And as a defense, lawyers say, we have to know what the universe of these cases are. You can't go to your clients and say, we need to write a check for $20 million unless you know who the actual plaintiffs are. So it's a real problem for both sides, and I don't know what the answer is, but I think, I think that your idea of holding someone accountable for properly vetting those claims to be sure they're meritorious and that they should be before a court at all.
Well, I got some takers for the pop quiz on my right, and I just wonder on my left, any views on this question?
Yeah. Sure. I mean, unmeritorious, unvetted claims is a problem, and they shouldn't be filed. No question. And this has been a hot topic in a number of different settings, and we get a lot of people talking and concerned about this. It's hard on plaintiffs' leadership, just as much. Maybe if not more at times than on the defense side, because two things are going on. One, if we're trying to figure out which cases to try and what to resolve, if people, if there are cases that, don't have value or very much value, that's a problem. But I think by and large, there's a lot of cases like that in my experience. If they really don't have value, there are tolling agreements, there are other things that are out there. It has not been a big problem in the cases that I've been involved with. I know it's always a question, but at the end of the day, claims administration processes and other systems are in place when we have global resolutions that deal with that. And certainly in the bellwether selection process and in the trial, we call them wave orders or something like that, where you work up a number of cases towards a bellwether trial. We usually find out at that point, we can get a better sense of, okay, if we're going to say, we're going to take 20 cases and we'll move them towards trial. If one of those cases turns out, or two of those cases turn out, like the plaintiff isn't interested in proceeding, or it's not a case that they think is worth pursuing, they dismiss. And there are organic ways through the procedures that we have to set up to eliminate that really getting in the way of us resolving the cases. I think another problem that we have that's the counterpoint to that problem is where we impose barriers to access to justice. So in both litigations I've been involved with, the Jewel case where you had teenagers that were victims, and now sex abuse survivors, these are complicated cases that the normal, ordinary course of, oh, we just, need to do a lot of vetting, or here we need a lot of plaintiff discovery and all these kinds of things. These are special populations where I've seen the result of overburdening early, in the interest of vetting, scare off and scare away meritorious claims. And we don't want to do that either. We want to make sure that our system is functioning so that, we are not a free-for-all for advertisers, to make money, and we're not imposing too great of burden so that real victims can't get access to justice or dissuaded or don't believe in the system. So
and not to make your argument for you, but there's also, the whole point of the MDL, or mass tort, which is a different thing but functions similarly in some ways, is to really bring down transaction costs in a way that allows the lawyers to focus on what's most important. And yes, it's true sometimes, and I've had a case where there clearly were a lot of claims that shouldn't have been there. If the method of getting at that problem is to raise the transaction cost of bringing any individual claim by creating a plaintiff fact sheet like process that's too onerous, then you will no longer be achieving the goals of the MDL. I think that's the argument, and I'm sympathetic to that argument. So I think these things are in tension with each other. There's not a sort of a here's the answer. If there was a here's the answer, we would be doing the answer. So more to be said on that topic.
I don't think I have a lot to add. I think there are both sides to it, and I also didn't mean to suggest, by the way, with garbage claims that it's necessarily primarily an issue of the plaintiff's bar, certainly not the plaintiff's bar we deal with. Part of what happens is when money becomes available, there are human beings out there who hear about it and would like some of it, right? And that's just a sort of natural way that things work. And going back to a long time, to FEN, when the MDL, defendants first tried to settle it, and I think they settled for about $4 billion, but as some of you may or may not know, you can't force plaintiffs to settle generally, right? So you put a settlement out there, you think, well, hopefully a lot of people are going to take it. And they tried to settle, and as it turns out, you put $4 billion on the table, and now you have a whole lot more people in the world who say, oh, I took FEN, and I had a bad reaction to it. And when it was all said and done, cases dragged on for years after the first proposed $4 billion settlement. I think they ended up paying $20 billion. So that's, I think, part of the challenge, right, is just once money appears, whether it's a result of the first couple trials going the plaintiff's way or whether it's a result of a settlement, it's trying to think about how you can actually put these things on a path to resolution, as we've all talked about, without incentivizing super marginal people to come out of the woodwork, with their hands out. So it's a super challenging problem.
I have lots more questions for these panelists, but I wonder, do any of you have questions that you'd like to ask or you'd like me to ask the panelists? You're the chief judge of the JPML sitting right here. Shall I answer your question? No. Okay, I got a taker on that one. Yes, sir. I'll repeat it after you say it so it'll go into the Zoom feed. Go ahead.
What do you think should be expected in leadership in kind of cases as someone who's not in leadership? I think there's a lot of expectation that might seem fair.
Yeah, that's a great question. I just want to ask a clarifying question. Do you mean what's expected of who they are in terms of being selected for leadership in the first place, or what it is that they are doing once they've been selected for leadership? Okay, terrific. So the question then was, for our practitioners, what do you think should be expected of leadership counsel and MDLs in terms of the way they're managing the litigation and dealing with each other in the court? Neil, you want to start us off?
Sure. It may be an easier question on the defense side because I think it's more common on the defense side that each defendant generally, right, has its own counsel who is speaking for the client. On the plaintiff side, there's more representation issues. I guess what I would say in general on the defense side, you're looking for somebody who is inclusive, and it's not just the oldest person who's done this the most, right, who's willing to hear other views. Somebody who's also, in terms, part of being inclusive, is willing to think about it. Just because you did it that way in the last MDL doesn't mean it's the best way to do it necessarily, right? There may be other ways to approach it. Ideally, sharing the mic, whether it's in court or whether it's in depositions, or otherwise. And I think you want that person to set the tone for how we're going to deal with the other side, which normally means being courteous and being professional and setting a tone in both directions, right? We'll be straight with you if you be straight with us. But also, if our side gets punched in the nose, then you ought to be able to punch back, right? That's part of what goes on in litigation. And so you're not looking for somebody whose first move is to punch the other side in the nose, but just mean that they're capable of responding when sort of our side is, feels a little bit aggrieved.
Yeah, it's a great question. I mean, so fortunately we get appointed through a court-appointed leadership process, and the leadership order typically lays out, what our job responsibilities are, right? And those usually include transparency and communication with the court, communication with the other side, setting the position of the steering committee and the plaintiffs, and communicating that position to the court, to the other side, and to all counsel, making sure everybody is in the loop, because there can be hundreds, maybe sometimes thousands of individual lawyers who have clients that they serve and who aren't sitting at the table in leadership. And you want to make sure that they have the tools and the information to adequately and zealously represent their clients and be able to communicate effectively with their clients so they all stay, in the flock. We also have the important job, right, of usually filing a master complaint or organizing the litigation, proposing ideas for how to move the case forward, leading discovery, leading strategy around trial selection, motion practice, that kind of thing. Those are a lot of functions that the court order will lay out, decide on settlement strategy, engage in settlement negotiations. We can't and wouldn't bind every plaintiff, but oftentimes the court will appoint us with the job to enter into negotiations, and we can reach agreements subject to each individual plaintiff having a decision. So those are functions. But I think the real question is, what is really expected, for this job? It is the best job in the world. It is an absolutely amazing honor and a privilege to be appointed to leadership by any one of these judges, and to have the faith and trust of the court to go and try to solve these problems. And this courthouse tackles some of the biggest, most important problems that have vexed regulators, that have vexed our governments, that we can't and haven't been able to solve. It's extraordinary what we get to do, and to have that opportunity to present one side and to organize that. And so for me, I take it really seriously that in terms of building that team, to focus on strengthening that team, being inclusive, hearing from multiple different, not just having tunnel vision, but listening to the diverse and strong and creative group around you, listening to the younger lawyers that are coming up, getting advice and counsel from those outside of your leadership group to create the strongest position and to build that team. My kids are just starting team sports now, and I see again how important it is to focus on the strength of your team and to invest in those relationships, make sure those goals are really clear to your team. What do we want to achieve in this MDL, and how are we going to get there, and getting feedback along the way. Those are things that are, I think anyone can do, because leadership can be learned. You can train. You can learn how to do that. And none of us are really born that way. It takes practice and learning. But I believe anyone can do that. And I think it's really important to take that responsibility really seriously.
I'm going to turn it over to the judges. I know the question was directed to the practitioners, but we're in the waning minutes of our program. I'd love to hear from you. What is it that you think, not as a great leader that you're going to pick to be in leadership, but you've got someone now in leadership, when they're doing a great job, what are they doing?
Well, this year, for the first time, I entered an order that said anyone who I appointed needed to come up for annual renewal. And I had not done that before. I required that they reapply, that they tell me what they had been doing, that they give me their hours. And it was terrific for me, because I could really see what was going on. But not only that, there were a couple of issues. And it gave me an opportunity to address those issues proactively, to make some adjustments, to shuffle some people around, to remind the leaders, the co-leads, that I put some people there who were not very traditional, and I expected them to help mentor them and to bring them into the fold, because I have I would like to make sure that we're building the bench, right? So for me, it's engagement. And and I can see, I know then who's working on which motions, and so I can see, are they doing a good job versus not? I do require that they have quarterly reports. I do not require an accountant because I figure, to your point on the money, even the lawyers have an incentive to make sure that no one's asking for more of the pie at the end of at the end than not. So they are themselves making sure that each of them is efficient. I would also say that funding the litigation is also important. And I always make sure that I have, at least at the very top, people who can afford to fund the litigation, because I don't have a ton of experience with litigation funders, but it's in part because I don't really trust the process so much. So that's another just practical consideration for, I think, more at the top, but that's why I'm trying to help diversify, and diversification in lots of different ways, perspectives, geography, all sorts of things, to make sure that I have people kind of rounding it out and that we're building a bench.
Judge Caldwell?
I would echo everything that Judge Gonzalez-Rogers has said, and really want to go almost back to fundamentals about what the practice of law is about. It's not about us. It's about our clients. And I think sometimes lawyers get so caught up in what am I going to do, how am I going to advance this, that we forget about the individuals that we represent. And what's really a challenge here is that leadership doesn't take on the representation of every single individual client in an MDL. I like to think of them as the captain of the team that is representing all of the individuals within the MDL. And when you're looking at a great team captain, you need, first of all, the experience to lead the team. You need the tools to lead the team, as in the funding, and these cases can be a challenge to fund. But you also have to look at someone who's willing to help develop other people. The best leaders care about other people and lifting them up. And that means not only their clients, but also other members on the team. I want somebody who's not just thinking about themselves or their clients, but understanding that they're part of something that is much larger. And I do think that the issue of litigation funding is something that we're all grappling with presently in assigning leadership. I mean, first of all, litigation funding is a way for plaintiffs and for young lawyers to get access to the courts, to get access for judgments, or to justice. But what we have to do is to make sure that those funders don't take control of litigation. And I think that's what Judge Gonzalez-Rogers is concerned about, as are many judges presiding over MDLs. Yeah,
it's the lack of transparency and the lack of inability to have them in front of us and know what's driving decision-making process.
We got a great question, but we're just about out of time, and some of us have an engagement that we have to get to later this evening, and we do also want to have reception. So I'm going to tell you what the question is, and if you're lucky enough, you can pigeonhole one of these people at the reception to ask them, and I think they'll tell you the answer, okay? And here's the question. How does the MDL court decide, and they mean the individual case, the court where the MDL is pending, not the JPML. How does the MDL court decide whether to try a few bellwether cases or instead remand cases to the transferor courts once common discovery issues have been completed? That's part style and part procedure. We'll talk about that outside. What I want to do now is, in a second, I want you to clap. But before you clap, I want to tell you that Judge Karen Caldwell is just as gracious all the time as she appeared to be this evening, and she flew here from Kentucky just to be with us. And from here, she's going to take a red eye to South Carolina so she can hear JPML business. So I want you to clap for everybody, but I want you to know how hard Karen Caldwell worked to be here tonight. So let's clap for these things.
You're very kind. Thank you.
And I do want to thank all of you for coming, and just to let you know that we are having a reception, and there are some refreshments right outside those doors. So thank you.